Give me the green light. Good afternoon. I'm Jim Duff, the Executive Director of the Supreme Court Historical Society, and I'm very delighted today to welcome you to our virtual platform for today's program with Professors Robert Post and Robert Gordon to discuss Professor Post's extraordinary work on William Howard Taft and the Taft Court in his landmark two-volume study, The Taft Court, Making Law for a Divided Nation, 1921 to 1930. His work was published earlier this year by Cambridge University Press as part of the ongoing Oliver Wendell Holmes Devise series. The Oliver Wendell Holmes Devise was established by Congress in 1955 to administer funds bequeathed by Justice Holmes to document and disseminate the history of the United States Supreme Court. The devise is now complete through the Vincent Court, and work is underway on the Warren Court era. Robert Post is a Sterling Professor of Law at Yale Law School. He served as the school's 16th dean from 2009 until 2017. Before going to Yale, he taught at the University of California at Berkeley School of Law. He specializes in constitutional law with a particular emphasis on the First Amendment. He is a member of the American Law Institute and a fellow of both the American Philosophical Society and the American Academy of Arts and Sciences. Robert Gordon is a professor of law emeritus at Stanford University. His expertise in American legal history, evidence, the legal profession, and law and globalization spans 4 decades. He has written extensively on contract law, legal philosophy, and on the history and current ethics and practices of the organized bar. Professor Gordon is known for Taming the Past, Law and History and Law, essays on legal history and the uses of history in legal argument, and also The Legacy of Oliver Wendell Holmes, published in 1992. Many years ago, we were able to host Dean Post, Professor Post, for a lecture series we did on the Chief Justices, where he shared his early insights into Chief Justice Taft. And we're delighted today to welcome you back with your work now completed. Professor Gordon and Professor Post are going to discuss the Taft volumes to begin with, and then we'll take your questions from the audience in the Q&A box at the bottom of your screen. I will turn it over now to our professors and look forward to this enlightening discussion.
Okay, thank you. What I'm going to do basically is to interview Bob Post about the book and to ask him to tell us about some of the many interesting aspects of it. This book is a monumental achievement. It's the 2 volumes, 1,600 pages in all. The heavily and thickly annotated. It is an extraordinary work of scholarship, and it's work of scholarship about 9 years of the U.S. Supreme Court's history, the 1921 to 1930, in which Taft was Chief Justice. But these were, as the book explains, kind of momentous years. Taft left a very, very deep imprint on the Supreme Court and shaped in many ways some of its modern contours. Could you talk a little bit about that, about Taft's role as Chief Justice and administrator in shaping the structure and the work of the court?
Absolutely. And I want to say what a pleasure it is to be here. And I'd like to thank the Society for this invitation, and to thank you, Bob, for this interview. It's always a pleasure to talk with you. So Taft was appointed Chief Justice in June of 1921. And if you look at the newspaper coverage of Taft's appointment, there was a general consensus that while he was a good judge, he was a terrible administrator, because he had failed as president in 1908. He got taken apart in the election of 1912. He won only the states of Vermont and Utah. So everyone thought of him as a terrible executive, but as a good judge. And so the newspaper commentary when he was confirmed was, gee, this guy will be a great judge, but he'll never be able to administer the Supreme Court. And it turns out that judgment was really terribly wrong. Henry Stimson, who served under presidents from TR to Harry Truman, thought that Taft was the best administrator of any president that he had served with. Taft was really terrific at management, and he was terrific at conceiving the Article III branch as a coherent branch of government to be managed the way he had managed the executive branch. And so Taft did a number of reforms which fundamentally reshaped the way federal courts work. The first and most important, I would say, from the point of view of Article III judges, was he proposed and he lobbied through Congress. And when I say lobbied, he is talking daily to President Harding. He is talking to the chairs of the Senate and House Judiciary Committees. He has his sleeves rolled up and he is walking the halls of Congress, talking to all of the senators and all of the representatives to get the Judiciary Reform Act of 1922 passed. And this act creates the Judicial Conference, which Jim Duff knows very well. And it imagined that Article III judges were a coherent branch that was there to perform service for the nation. Before that, we appointed judges, and each judge was responsible for his courtroom, and they were entirely independent of each other. But Prohibition had come along, and there were some districts that were greatly in arrears in their docket, and others which had too little work to do. And Taft said, well, they're all judges, so why don't we transfer the judges from the districts which are underutilized to the districts which are overutilized? So we conceive the judges as a whole, not as each individual judge. And to do that, it required the collection of judicial statistics, which had never been done. Which district courts were in arrears, which circuits had too many or too little district judges. So he creates the managerial package. He creates the annual conference of heads of the circuits, and they meet each year and they become a force for reform. They propose many reforms, and Congress grants all of them. They propose many new judgeships because we need a new judge here or a new judge there. Congress grants virtually all of them throughout the 1920s. It becomes the voice of the judiciary, which never had a voice before that. And as a result of that, Taft understands himself to be the head of the federal judiciary. Chief justices before that wouldn't have conceived that. Now we have the State of the Judiciary speech, which the Chief Justice gives. It's analogous to being president. And so Taft imagined the conference as his cabinet as he governed the judges, just as he had governed the executive branch through a conference. Totally reshapes our understanding of the judicial branch. So that's one reform. Second major reform is the Judiciary Act of 1925. And the court before that, the jurisdiction was largely composed of mandatory cases. John Clark resigns in 1922, much to the dismay of the liberals on the court. And when he writes his letter to Woodrow Wilson resigning, he says, I can't do these cases. They're mostly trifling cases. They're bone hard labor. And who cares where you put an irrigation ditch? Who cares whether they're taking over somebody's farm? And yet we have to decide all of these completely trifling cases because of our mandatory jurisdiction. It's a waste of my time. I'm going to resign and advocate for the League of Nations. That's what he writes Woodrow Wilson in 1922. And really all the judges felt that. Sutherland testifies before Congress that we have too many trifling cases. Half of our cases have no business being here. So Taft, since 1908, had been proposing a reform in which he said, look, any litigant is entitled to one trial and one appeal. And after that, the community has no investment in giving him a second appeal. The function of the highest court, of the Supreme Court, is not with respect to the litigants, it's respect to the legal system as a whole. And we're here, the Supreme Court should be there to decide important cases, which means to supervise the development of federal law. That's the function of the Supreme Court. And the only way we can do that is if we have discretionary control over our docket so that we decide which cases are important and which cases not important. And so that was built into the Judiciary Act of 1925, which Taft has the court draft. When he gets appointed, he creates a committee to draft this. The court drafts it and gives it to Congress to enact. And this is, quite a no-no at the time. And Vandervander was very discreet, is always writing Taft to say, look, remember, you didn't propose this. They asked for this, which is not true. He proposed it and he put it into, he gave it right to Cummins, who was the chair of the Senate Judiciary Committee at the time. He says, Albert, I have this act I need you to enact. We have a letter in which he basically says that. And Vandervander is always saying, oh, we thank you for inviting this. We know you need us to write the details, so I'm happy to draft it for you. But of course, we wouldn't tread on your toes. And many senators are saying, and congressmen are saying, it's a really good thing the court didn't propose this. It would be a bad thing. But of course, they did, because Taft was very aggressive. He imagined his role more as an English Lord Chancellor than as any justice, American justice ever. So he imagined himself as supervising the system of law and as like an executive official, proposing changes, making reforms, lobbying, sitting on judges who were recalcitrant and were behind in their dockets, who were district court judges. He was in charge of the whole thing. No Chief Justice before or after has ever imagined himself that way. But Taft, who was a former president and comes into the Supreme Court, has this conception of the role. And so the Judiciary Act of 1920 fundamentally changes the way the Supreme Court works. It now is in charge of its own docket. It's now imagining itself as writing proactive law. And this, for very many deep reasons, completely changes the meaning of Supreme Court decisions and the way in which the court fits into the system of American law. And his third great reform, I mean, these are great reforms. He has many, many, many reforms, but these are the great ones, is he decides that he is going to get a new Supreme Court building. This is provoked when Stone is confirmed to the court in 1925, and he writes Taft and he says, I have no place to sit. I don't have a home in DC. He's moving from New York, and I need an office in the Capitol. Remember, at that time, the Supreme Court was in the basement of the Senate side of the Capitol. And Taft says, yeah, I'm going to try and get you an office. So they go begging, and he's temporarily put in this committee's office and that committee's office. And Stone is whining. He's saying, look, I'm in the basement. I don't have sufficient light. What am I going to do? And Taft says, And I think the reason he says, is he's trying to get a Supreme Court building before, but he only has 4 votes. And he sees Stone is going to want to have a Supreme Court, he's going to want to have an office. So now he's got 5 votes. So he says, I think I'm going to go for a new Supreme Court building. And he takes it to the conference, and he has a 5-4 vote to get a new Supreme Court building. Stone's the 5th vote. And then he goes lobbying. And I mean lobbying, I mean sitting in Smoot's office to get it into an appropriation bill. Smoot decides he doesn't want to do it, but Taft is not going to be denied. He sees that there's going to be a conference on an appropriation for new building between the House and the Senate, and he goes to the members of the conference committee. He says, put this in, even though it was in neither the House nor the Senate building, and out pops a $12 million an authorization for a Supreme Court building. And then he sees it through, and just months before he has to resign in December of 1929, they finally approved the $12 million appropriation, which creates the bill. And of course, Taft worked closely with Gilbert to design the building.
One of the most interesting features of the Taft Court and of this book about it is Taft's relationship with some of the other individual justices on the court. Taft had appointed some of the justices himself, and he was later to influence the appointment of more, but he also inherited a couple, whom he had not appointed and would not have appointed, Holmes and Brandeis, the 2 justices whom we most remember from that court. His relationship with Brandeis could have been particularly contentious, right? Because he had opposed Brandeis's confirmation to the Supreme Court. He was a leader in the fight to deny Brandeis confirmation, and also he and Brandeis had tangled before. Brandeis, in fact, acting as as a very aggressive lawyer and advocate, had seriously questioned Taft's truthfulness and integrity in hearings over the so-called the Ballinger-Pinchot affair, which the details of which need not concern us since they're complicated and looks to many modern observers like a tempest in a teapot. But anyway, there was real reason for antagonism between the two. When Taft took over as Chief Justice, how did Taft and Brandeis actually get along in their time together on the court?
It's actually an amazing story, in today's days of polarization, where, people don't talk to each other. This is it's a fantastic story. Brandeis would have voted for Taft in 1908. He says, look, Taft is going to make a pretty good president, he said, of the Grover Cleveland type. That was his opinion of Taft in 1908. And then along comes this scandal in which Taft's Secretary of the Interior, Ballinger, is accused by Gifford Pinchot, who was a Roosevelt holdover, of doing kind of bad things. And Brandeis gets involved in it. There's a Senate hearing to determine whether or not Ballinger acted badly in firing a certain member of the Interior Department. And Brandeis becomes basically the prosecutor. And he was not only a brilliant appellate lawyer, he was an amazingly good trial lawyer. And he proves by sheer instinct and gut, but he manages to prove that Taft had denied that a memorandum existed in which he depended in which he consulted in upholding Ballinger's firing, and that he had backdated a much later memorandum, which his Attorney General Wickersham had written. So basically, Taft had messed it up entirely. It's not so clear there was any actual wrongdoing, but the confusion and the dishonesty about this memorandum really tarred Taft and helped to destroy his administration, the credibility of his administration. So Taft hated Brandeis. He thought that he had prosecuted Ballinger, who had never done anything wrong. And he has in this letter says that I would be untrue to myself if I didn't defend him. And in Brandeis's view, this was the corruption of big business and he came to call Taft the fat man. He really thought he was a fool because he had messed up the defense, and he had actually in many ways. And so when Brandeis gets nominated to the court by Wilson, you have to understand this is in the context in which there's a home move by Southern Democrats that Wilson should nominate Taft to this position. So there's a whole Taft boom. You should nominate Taft. And instead he nominates Brandeis, and Taft is fuming at this. He writes his best friend, who's a reporter for the Cincinnati Star, Gus Carger. He says, "Es ist zu lachen." It's to laugh that he would appoint this person who has such a terrible jurisprudence and doesn't believe in the Constitution instead of me, he says. And so he leads an effort by the ABA presidents to say Brandeis doesn't have the character to become a Supreme Court justice. He gets with Lawrence Lowell, the president of Harvard. He gins up this letter, and so the letter circulates. Brandeis is confirmed. So there's Brandeis sitting on the court, and then we have this letter, 1918, from Brandeis to his wife. At that time, Taft was chair of the War Labor Board, which means he was in charge of setting labor policy for the United States in the time of war. And this is a really interesting thing because we needed labor stability in order to have a wartime economy, which means Taft has to lead the board to recognize unions, to overturn Supreme Court decisions which say you can't prevent an employer from firing a union member. There's decisions which hold this, Adair, and the War Labor Relations Board under Taft overturns all these decisions, basically saying you have to respect unions, you have to have a living wage, etc. It's the most union-friendly administration that had ever existed, and in fact encourages rapid unionization throughout the United States. And of course, Brandeis was a strong supporter of unions and had theorized unions long before. So this is 1918, and Brandeis writes his wife, "I'm walking across the bridge, which is now Taft Bridge over Connecticut Avenue in Washington, D.C., and this car stops, and out pops Taft. And he walks up to me and he says, Justice Brandeis, I presume. And he says, yes. And then they have this conversation. And it's such a great conversation. Brandeis invites him up to his house. And he has this conversation, lasts all afternoon, with, he says, Taft putting his hands on my knee and talking. And they have a long conversation in which Taft, they talk about labor policy, in which Taft compliments him and inquires from him. And so they make this reconciliation. And later, Brandeis says, I never thought I would live to see this day. It was really interesting. So then Taft gets confirmed. Brandeis reaches out to him. He says, I know you're interested in judicial reform, so am I. This is a great thing. So he picks this neutral subject. And Taft uses him. He appoints him to the Committee on Accounts. Brandeis revises the whole accounts of the court, and he thinks of Taft. He thinks of Brandeis. Taft thinks of Brandeis as a really good person who, to use a phrase Taft always used, mans his oar in the boat. He pulls his oar because he was, he wrote a lot of opinions, very good. He says, I just can't trust him on constitutional issues. Any other issue, he's really great. Administrative law, I like him. I like him on, private equity, on jurisdiction. I just don't think he has his head screwed on writing constitutional law. And he thought the same of Holmes.
So let's talk a little bit about those constitutional cases, on which Taft thought that Holmes and Brandeis and increasingly Harlan Stone were unsound. Now these are mostly labor cases and 14th Amendment cases, and the cases in which you argue Taft took a quite distinctive and view of the rights of property, and a more conservative view than his War Labor Board experience would suggest. And in those cases, those are the cases in which Holmes and Brandeis were most likely to dissent. So could you talk a little bit about Taft's views of the rights of property, and then about Holmes and Brandeis's dissents and the ways in which they were alike but not alike?
Oh, yeah. So this is really fascinating. So think about the 1920s. We think of the 1920s as kind of this flapper era where everyone is running around drinking gin and having a good time. But actually, it's a time of immense polarization in the United States. You have to think of labor. This is what they call it industrial warfare. I mean, there are strikes which come to the Supreme Court, and the description of the strikes are they're bringing out the national militia. They have machine guns. They're stocking up the ammunition for the fight. So labor is really intense, and physical violence. And prohibition is the same. People are being killed right and left over prohibition. And the war between the wets and the dries in the United States is so intense that 1920 is the only time in the history of the country that Congress did not reapportion based on a census, because the census would have given more strength to the cities, which were wet, and the dries in Congress were not about to let prohibition be undermined by having more urban representatives. And so we're talking really steep polarization over prohibition and over labor. Those are two things which were quite controversial. There are other things, but this and immigration, of course, quite controversial. But these were two issues which reached the court. And how to make law in a time of polarization like ours is a very deep problem, because law has to be acknowledged as authoritative by all sides to a controversy. So what theory would you have which would potentially reach out to all sides of a controversy? So Taft had a particular theory of what constitutional law was about. He thought it was about protecting the rights which would make America prosperous. Remember, this is the 1920s, the decade of prosperities, as Leuchtenberg calls it. And he thought what Americans cared about, more than they cared about any legislation that their state legislatures or the Congress happened to enact, was that they remain prosperous. And what is the foundation for prosperity? It's strong property rights. So the function of the Constitution is to keep Americans committed to America because they have a common interest in prosperity. Now, when people talk about neoliberalism or talk about the economy as prior to politics, this is what Taft and Sutherland and Vannevanner and Butler all believe. They believe that more fundamental than any political legislation was the commitment of Americans to a prosperous economy in which there'd be economic growth. And to do that, you needed to protect property rights. And so Taft reads these into the 14th Amendment. And one of the things that he does is he leads the court. He doesn't actually lead the court. He presides over a court which revives Lochner. Lochner was presumed dead by the 1920s. Indeed, Cardozo's lectures on the nature of the disjured process in 1921 say Lochner is behind us, thank goodness. And then in 1923, the court in Adkins, Sutherland, Taft dissenting on this opinion, revives Lochner in a case about minimum wages for imposing minimum wages for women in the District of Columbia. After that, I should say Taft begins to suffer heart attacks and strokes starting 1926, and his brain starts to deteriorate. And as it starts to deteriorate, he becomes more and more reliant on people like Sutherland, McReynolds, Vandevander, the extreme right wing of the court. And so he becomes much more compliant about property rights. Before that, he had a very strong political sense of how far you should go and shouldn't go in protecting property rights. But in the second half of the decade, he just gives that up and he just goes with the conservative side. In dissent are Holmes and Brandeis in this, and later, as you say, Stone. Holmes is in dissent because of a very interesting thing about Holmes. Holmes invents what we now call positivism. So most American courts in the 1920s imagine themselves most fundamentally, and this is true of the Supreme Court too, as common law courts. They imagine themselves as speaking for the sentiments of the American people, the deep norms and values of the American people. So you see this in the federalism cases. When the Taft Court decides cases about federalism, they're speaking neither for the federal government nor for the state government. They're speaking for the American people as a whole. After Erie, after the Supreme Court adopts positivism, our court now says, I'm either speaking for federal law or state law, because you have to have a source in law. But as a common law court, you have a source in common sentiments and beliefs. And that's the way they actually interpreted the 14th Amendment. That's the way they interpreted federalism cases about nationalism, the Dormant Commerce Clause, etc. These were all done out of a sense of, I'm speaking for the customs and traditions of the American people. The justice who was most clear about that was McReynolds. And Holmes grows up in a legal system in which, if you look at the addresses of the presidents of the American Bar Association in the 1890s, they say lawyers should contrast legislation and law. Legislation just happens to be a bunch of people who gathered at the state capitol on a given day. It has no validity. Law are the deep customs and traditions of the American people, and your loyalty as lawyers is to law. And that's why judges, when they were appointed, imagined themselves as loyal to the law. And Holmes, who grows up in the Civil War, says, what do you mean the common customs and traditions of the American people? The American system is about conflict. It's about turmoil. It's about disagreement. It's a constitution made for, as he says in his Lochner dissent, many different views. There's not one view. So this common law, speaking for the common law, speaking for the common sentiments, that's nonsense. We have no authority to make law. The people who have authority to make law are the people who speak for what he calls in his Lochner dissent, the right of the majority to make law, the sovereignty, the dominant forces in the community, which are expressed through the legislature, not through courts. So that's the beginning of American positivism. Mostly we're positivists now. He wins this battle, and he wins the battle by denying that there are common customs and traditions. And so he says we should defer to legislatures. And we have to defer to them no matter what they do, because they have the authority to speak for the sovereign state, because the majority is what's sovereign. So he defers, and he always defers to state legislatures. And so when the court says we're protecting property rights, he says what the property right is, what the law is, depends on what the legislature says, not what a court thinks is beliefs about property. Now, Brandeis also wants to defer, but he wants to defer for an entirely different reason. Brandeis is such an interesting justice. He develops two theories which are fundamental for us today. The one is the legal process school. He says there are different capacities for courts and for legislatures. They have fact-finding capacities. We don't. They have the capacity to reflect popular judgment. We don't. And so we should defer to them on issues that require fact-finding and a responsiveness to popular judgment. And he says, look, what does it mean to enforce it? What is the fundamental of our Constitution? For Taft, the fundamental was economics and prosperity. The economic was prior to the political. For Brandeis, the fundamental fact of our Constitution is we were a democracy. The political was more fundamental than the economic. And so we have to reach out to protect those rights, which are necessary in order to have a democracy, in order for people to be democratic citizens. Just think John Hart Ely. He's like John Hart Ely. And so a good case that separates Holmes and Brandeis is a case called Meyer versus Nebraska. So World War I, which is crucial in understanding the Taft Court, America went crazy in many, many ways. One of the ways they went crazy is they hated all things German. So they had a law in Nebraska, you couldn't teach German to kids. And so this comes up to the Supreme Court. And McReynolds writes the opinion. He writes the opinion saying, custom and tradition, of course, we have a right. The common law, the 14th Amendment, protects all sorts of basic rights. And including that is the right to learn languages, the right to have access to that. Brandeis joins that opinion. And he joins that opinion because, as we see later in a conversation with Frankfurter, he thinks the right to an education is necessary for democratic citizenship. Holmes dissents. Holmes says, there are no rights like that. There is no constitution like that. There is only deference to majorities. So they had a perfect right to say, we want people assimilated into English as a language. So he dissents. That encapsulates the difference between Holmes and Brandeis. They often came to the same conclusion for entirely different reasons. So Holmesian positivism really is a precursor to Rehnquist. Rehnquist is a conservative deference on all things virtually to the states. That's a revival of a kind of Holmesian positivism.
Robert, we have limited time, so I wanted to
So
finish up by asking you to contrast two different areas of Supreme Court cases. One has to do with prohibition. One of the great things about this book, you have 200 pages on prohibition, a now largely forgotten episode in American history, but one of enormous importance for its time. It involved the federal government and especially the federal courts in an unprecedented level of control over routine aspects of American life and economy. Now, in the prohibition cases, Taft seemed to be quite a strong positivist. He upheld the authority of, he didn't believe in prohibition, thought it was a bad idea, misguided in every possible way, but he was determined to uphold the authority of American law and American courts against widespread civil disobedience. The law should be upheld. Contrast this with the court's attitude in race cases. The 14th and 15th Amendment had as part of the settlement of the Civil War, given the federal government an enormous amount of authority to achieve at least formal equality between the races in the South. The white South resisted this attempt, as now everybody knows, of course, and in this case, Taft did not try to exercise the authority of law and of the federal courts over what was essentially the lawless resistance of the Southern white establishment. Could you say a bit more about those two areas of lawmaking?
So prohibition, 18th Amendment, suddenly the federal government is regulating consumption by ordinary Americans of liquor. This is an enormous expansion of federal authority, and they didn't have the ability to do that. So it raises all kinds of questions of federalism. But the deep issue, jurisprudential issue, was it overrode the customs and traditions of half the country. Literally half the country acted as if prohibition wasn't in place. If you go to New York or Philadelphia or San Francisco, you could get a drink and people flagrantly violate prohibition. Just think of Sinclair Lewis, remember Babbitt? And Babbitt is having a cocktail party with his friends, and he's having a dinner party. And he says, anyone ready to break the law? Let's have some cocktails. That's the way it was regarded, as not authoritative as law. And so the idea that federal law enacted in the Constitution, ratified in the Constitution, should override custom, this splits the conservatives. Half the conservatives, Sutherland and Butler and McReynolds, say we have to take the edges off prohibition. We have to make it the least possible intrusion on custom. And so when they ask the question, does the federal government have the power to regulate the consumption of liquor? To regulate the prescription of liquor by doctors, they say no. And they do that because they want to minimize the intrusions of prohibition on custom and tradition, because then it's violating law, the most basic law. But three conservatives led by Taft, Sutherland, and Sanford say, no, we have to uphold law itself, because if we don't uphold the law itself, we are condoning lawlessness. And the suppression of lawlessness is a real big theme for Taft at that time. Think KKK, think race riots and lynching, think prohibition. We have to contain this lawlessness. And so they want to uphold it. And so they sign off on and write a set of decisions which are just like Holmesian positivism. The law says this, that's it. That's the end of the story. We're going to give the power to the federal government. Custom and tradition be damned. We don't care. And this paves the way, I think, for the New Deal, because this is the administrative state overriding custom and tradition completely. Contrast that to race. The Taft court unanimously upholds Plessy in a case called Gangwon. There is no one on the Taft court who understands the Equal Protection Clause as protecting racial minorities. This is not understood to be the case on the court. So they unanimously uphold racial segregation in Mississippi. And Taft himself knows that this is a violation of the South is violating the 15th Amendment and the 14th Amendment. And he says, I can't do this because it would be I'm powerless against the customs and traditions of white Southerners. I have to concede to them. So notice in prohibition, he's willing to override custom and tradition, but in Southern race matters, he's not. And that's true for the whole court. There's no one there who's willing to go against those customs and traditions. And so this is the height of Southern apartheid in the 1920s. And the theory of the book, Sanford dies in 1930, and Hoover nominates John J. Parker to replace him. John J. Parker was a Republican from North Carolina, and the NAACP carries on this campaign against him because he is against Blacks participating in the political process. And they mobilize enough Blacks who are now voting blocks in the border states because of the Great Migration, that his nomination is defeated. And all the political commentators throughout the country say, this is the first time we've seen Black power since Reconstruction. And my theory is you don't get Caroline products, which is reinterpreting the Equal Protection Clause to protect discrete and insular minorities, until Blacks show themselves to be a discrete and insular minority that's capable of participating in politics, i.e. killing a Supreme Court nominee. So what this is showing is you don't get rights of political participation until you show that you are a political participant, and then the court will start giving you the rights.
Thanks. You've accomplished a lot in a short time. Just to summarize some of the principal theses of the book, I think it's now time to turn this over to the audience. Isn't that right?
Well, thank you both very much. I hesitate to interrupt because but we do have questions from the audience, and I think it will just help continue this conversation, because in recitation, it's fascinating, Professor Post. But the first question we have is, while undertaking your research for this masterful project, what was the most interesting archival anecdote or piece of archival material that you found? And I have a follow-up question of that on my own, but
I'll tell you the most wonderful one is I was rummaging around in the attic of the Supreme Court with Gail Galloway, who was the archivist at that time.
Yes.
And we came across a locked trunk. So I said, what's in this trunk? And they'd lost the key. They didn't have it, so we had to call a locksmith. So we got a locksmith, we opened the trunk. We found a lot of interesting things, but the most precious thing we found, we found these locked leather volumes, about 10 of them, and we couldn't open them because we didn't have the lock. So we called back the locksmith and we opened them up. They were Butler's docket books for 1923 and 1924 terms, and Stone's docket books for the whole 20s. This is amazing because docket books, record the voting in conference. And there was a ritual which the justices would burn their docket books at the end of the term, because the voting in conference is supposed to remain confidential forever. So suddenly I had access to how they voted in conference, and I can in the book show how they voted in conference versus how they voted in the actual opinions. And I can show, for example, that the rates of dissent in the Taft court are extremely low. The average opinions are 85% unanimous. But that's not true in the conference. And so it's not that the justices aren't disagreeing, but they have what I call a norm of acquiescence. They give up their dissent. If you look at the circulation of opinions, Holmes is always saying, "I'll shut up," or Brandeis will say, "This is dead wrong, but I'll keep quiet," or things like that. So they're always censoring themselves. It's a norm of acquiescence, not that they agree, but that they acquiesce because they shouldn't dissent. They agree that the court's opinion is more important than their own dissenting opinion. So to explain the collapse of the expansion of dissent rates, the collapse of unanimity, one has to understand why it is that justices no longer believe that a court opinion is more important than their opinion. And that's a different level of explanation than political scientists have been engaged in. So the book tries to think about that. But it was absolutely wonderful to see how people voted in Gitlow, for example. Gitlow is the first case to apply freedom of speech to the states. Taft dissents. He wants to protect the speech in Gitlow. Who knew that? And he wanted to do it for a guy named Gitlow, who was, this really radical red, who, like many radical reds in the 20s, turns conservative in the 50s and campaigns for Robert Taft for president. Taft's son in the 1950s.
To what do you attribute the unanimity or the agreement among the justices to try to publish unanimous opinions rather than have dissenting opinions? And was it Chief Justice Taft's leadership, or
people always say it's Taft's leadership, but if you look at the White Court and the Taft Court, and indeed the court going all the way back, the unanimity rates are in the same range. They're in the range from 75 to 92%. Right, so Taft can change it within a small margin, but if you look at the unanimity rates now, it's in the range from 28% to 40%. It collapses during the late 1930s and 40s. So we're dealing with a phenomenon that's not any given Chief Justice's leadership. It's the phenomenon of how law is conceived and how the authority of the court is conceived. So they understand the function of the court to be, and I was just looking this up today, Cardozo writes in his treatise on the New York Court of Appeals in 1909, he says, what's the function of the highest court? Is to settle the law. So they imagined that what the court does is it applies professional reason and it settles the law for all time. Law is fixed. Once I've settled it, that's it. And once they begin to imagine that law changes over time, then the function of a dissent changes over time. It becomes what Charles Evans Hughes says is an appeal to the imagination of a future court and a different intelligence than ours. So they imagine that law has to be legitimated in intelligence, so you can never fix it. It's a developing thing. Even Cardozo, the legal realist, imagines that a high court is settling law. It's a deep change in the imagination of America when they imagine law itself is changing. And one of the things about the Judiciary Act of 1925 is it forces the justices to imagine law as malleable in their own jurisdictional practices, because every time they vote to accept or deny cert, they're imagining a different future for law. They're constructing the law. They have to be constructing the law by decisions to grant or deny cert. So it puts that right in the middle of their consciousness.
It's great insight. The question I had in your research that I found so intriguing is when Taft's advocacy with Congress about the creation of the Judicial Conference and the self-administration of the courts, which is so important to its independence. Was there resistance in Congress to his, I know you've said that he lobbied very hard,
yes,
but was there resistance, and what was the basis of the resistance?
Well, Clayton, for example, Henry Clayton, Clayton Act, who was a representative at the time, says judges aren't like soldiers to be ordered about. it's not a military, it's not a managerial form of authority. So there were a lot of people who thought that this was bad because it misunderstood the role of a judge. They shouldn't be under administrative authority. So that was one objection. A second objection was this would make judges national. And the idea that judges are local is very deeply ingrained in the American system of justice. So Southerners didn't want Northerners coming in to decide race cases. And people in New York didn't want Southerners coming in to decide cases about prohibition. So there was a sense in which federal law was really a local matter. And the idea what I forgot his name, Spencer, I think, Senator from Tennessee, calls it a flying squadron of judges. And later on, you see these objections to judges coming into New York, where the Southern judges would come in and they'd say, how is it that you can believe a Negro witness? They say to a New York jury. And LaGuardia is writing Taft saying, what kind of judges did you appoint in the South that they come here and say that? Don't ever have a judge like that come to New York, So there is this notion that national law isn't national. We now imagine it to be national, but that's in part a function of the mobility of the judges and World War II and all sorts of things. But in 1921, federal law did not have that quality.
Interesting. Thank you. Questions again from the audience. Did natural law figure into the debate over positivism?
Well, natural law is a very difficult subject to pin down in the United States. You will see lots of rhetoric. Brewer, for example, was a justice who loved the rhetoric about about natural law and it's inherent in the universe and God gave it to us and blah, 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 blah. You see this rhetoric, but I don't think you see it ever anywhere in the United States as a serious jurisprudence, except in this sense. They think of law as already existing. But the law they think of as already existing is the customs and sentiments of the American people. It's not God's customs and sentiments. It's not nature's. It's what people think. And they can call that natural as a metaphor. But really it comes out of, and this is odd to think of America this way, but it comes out of Hegel. It comes out of Coolidge Carter's work in the late 1890s and theorizing the relationship of custom and tradition, which is to say a Hegelian sense of society and American law. That's where it's coming from. And I think that's what natural law means, but it's really common law that they're talking, what we would now call common law. Would you say that's right, Bob?
Yes, I think that's right. I mean, the term natural law is used a lot, by particularly in after dinner speeches, and in the occasional aside in opinions. But its practical import is very low if you're thinking in terms of classical natural law. There's the references to natural law are almost all rhetorical, rather than operational.
There's a natural law theorist now, Adrian Vermeule at Harvard, who really wants to say natural law in Aquinas' sense. But I don't think there's an American in the 20s who would be saying that.
I wanted to add one more a question, because you have resurrected from obscurity in this book Willis Van Devanter as one of the most important justices on this court. He didn't write very much. He had trouble writing his opinions, but he was a very influential justice, you argue. Could you say more about that?
Sure. I mean, Van Devanter is always, when political scientists do judgments, he's always like the least successful justice. And that's because he had a writer's block. Sutherland, one of his best friends, called it pen paralysis. And everyone understood him to be an OCD type. He just everything had to be perfectly arranged. He comes, and this is really odd because he comes from Wyoming, where he goes on hunting parties with William Cody, Wild Bill Cody, and he is involved in the Prairie Wars and really a Westerner out hunting and camping and everything else. He comes to DC and he becomes this tight person. And he's so tight, he's a perfectionist. He can't write these opinions. But in the conference, everyone relies on him. Every justice, chief justice from White to Taft to Hughes, to stone says when he delivers himself in conference, it could be a perfect opinion, just like transcribe him, and he's got the opinion, and he's extremely influential with everybody. I mean, and it's not political. He is an extremely reactionary justice, but endlessly Brandeis is sending his opinions to him and saying, "Could you look at this? I need your advice on this." And he's correcting and he's taking in hands everybody. Brandeis calls him Taft's cardinal. He said, because he is always administering, and Taft called him my chancellor. He is the one who drafts the first certiorari rules. He drafts the Judiciary Act of 1925. He's a great draftsman, and he can do that without any problem. But drafting an opinion, he's got a real problem. And so I have a study, actually. I did a statistical study of per case who is most likely to attract votes, change votes in conference. And it's Vandewander by a very large margin. He is the most influential judge on the court. He can attract more votes to his opinion. Tract by tract, I mean, get them to change their votes than anyone else. He has a lot of good faith. I myself view him as he's basically a dishonest person in many, many ways. He is very sly. He wants to be everybody's friend. But he's always playing the angles. Just to give a simple example, when he's lobbying for the Judiciary Act of 1925, Taft comes before the Congress and he says, "Look, we need this because we have too many cases and we have to control our docket." And that's the main reason. That's what Taft says. That's the primary reason for this. Vandewander gets up and he says, the primary reason, literally, he says, the primary reason for this is we need to codify all these ways to get to the Supreme Court because nobody knows how to do it. Now, he does codify it. That's very important, but that's not the reason they were doing it. And everybody knows that's not the reason they were doing it, but that's what he says to the Congress. He's that sort of a person.
May I go back to something you mentioned earlier, Professor Post, about the traveling judges in the aftermath of the creation of the Judicial Conference? It's a little bit different than the current system that we have. I mean, there are inter-circuit assignments, but Chief Justice Taft, he proposed a concept that I had seen referred to before as floating judges. Is that what you were referring to when he was sending judges to New York, for example, from the South? Or how explain a little bit about how that?
So his idea was originally, I'm going to quote, I think it was 12 judges without any district, and they were floating. And Congress said, no, we're not going to do that.
Okay.
So Taft, being very practical, said, okay, I'll give that up, but I want to be able to transfer judges from circuits which don't need them to circuits which need them if I get the okay from the circuit from which they are departing and the certificate of need from the circuit to which they're going. And so he uses these transference procedures to get people from, say, Arkansas into New York.
Yeah.
And vice versa.
Workload. Yeah.
He develops these transference mechanisms which didn't exist before. Before that, there was only the ability to get people to New York, because New York was so always in need and always so behind in its docket.
Thank you. And the inter-circuit assignment process still exists today. So another question from the audience, and Professor Gordon, please chime in too with your own questions, because it's just a fascinating conversation. I wish we had 2 hours to do this in. But here's a question. The person is curious about Taft's views on women's suffrage achieved in 1920 after serious engagement with and against President Wilson. Did he have a record on this issue prior to his Supreme Court service?
I actually don't know the answer to that question. His daughter was president of Bryn Mawr and was very much a committed suffragist, but I don't know what Taft's position on that was, so I can't answer that. There was a case before Taft became Chief Justice of whether the 19th Amendment was constitutional. And it was argued that it was an unconstitutional amendment because it changed what the nature of the polity was. And the court just says, per Justice Brandeis, forget that. There was also an argument before Taft gets on the court that the 18th Amendment was unconstitutional. And Vandewander says, forget that.
Here is a pretty detailed question. You made the fascinating point that Justice Stone would not have written paragraph 3 of footnote 4 of Caroline Products until discrete and insular minorities had demonstrated themselves capable of exercising political power. But isn't the point of paragraph 3 to say that the court needs to look at legislation harming discrete and insular minorities exactly because prejudice curtails their effective participation in the political process? Could you elaborate on your
Yes,
point?
you're exactly right. That's the point of footnote 4. But if you look at Stone's vote, and here I can say this in conference in Gangnam, he has no, he says, gee, there's a little problem here, but there's a problem technically because actually the claim was I'm being discriminated against as Chinese when I'm being put with African Americans. That was the actual claim. And he says, and the answer is rational basis. That's what he writes to Taft in the when Taft is writing his opinion, and he goes along with the opinion where Taft doesn't say any of that. So Stone had no conception of the Equal Protection Clause as protecting minorities against whom there's prejudice. And that's apparent if you look at the court's decisions during this period. It's immigration decisions, it's alien property decisions. The court is saying the instincts of the population about who is white and that there should be white privilege, we will never disturb that. And as Plessy says, it would raise more problems than it would solve to do that. That was their explicit jurisprudence. And so the question to be answered is why by 1938 does this jurisprudence change? Why is it that the court imagines itself as protecting minorities? And I think it's because now minorities are putting in a political claim such that it's visible that they are being oppressed as a political minority.
Mm-hmm. Thank you. Next question. Do you think one reason Taft, after his Adkins dissent, goes along with Lochner-style decisions is that he and the others had a different view of dissent than current justices or more recent justices have had?
That's definitely true. And Stone goes along, for example, with Adkins in several opinions, and he gets excoriated in the pages of the New Republic. It says, the New Republic says, and this is a case that affirms by memorandum opinion striking down a minimum wage statute. It says Stone prefers to huddle in the warmth of majority than to shiver in the outside with Holmes and Brandeis. It says about Stone, and Holmes writes Lasky saying, "Don't misjudge Stone. He's doing this for a different kind of reason." And we know from Stone's own correspondence, he's doing it because he doesn't want a dissent. He thinks that once the law is settled, he's got to respect it, which is a really interesting thing. It means that, by the way, by the end of the 1920s, there's 5 votes against Atkins, but nevertheless, it's good law because they believe about dissent. But that's not Taft, because there's a lot of opinions which are applying the principles and expanding the principles in which you could dissent, and Taft doesn't. And so I don't think that explains Taft, but it certainly explains Stone. And what's interesting about this is when the court decides Nebbia, when it decides later on about, West Coast Parish, when it decides the minimum wage in Washington, in the Pacific Coast states, they had never stopped applying minimum wage laws, even though they were unconstitutional, because the businesses liked it. And so there was no one to challenge it. So these laws, which were unconstitutional everywhere else, were common on the West Coast. And that's how that case arises. Isn't that interesting?
Very interesting. Here's some input from our audience on women's suffrage. On the suffrage question, Taft's high school graduation speech was in favor of women's suffrage, but as president, he said it should be up to the states. In other words, not supporting an amendment. But an interesting observation. Well, we are coming to at the end of our time together, and I wish that weren't the case because it's been fascinating, and I'm so grateful to both of you for your time today and this fascinating discussion. I would say that copies of the Devise are available on Amazon. I don't know that we're carrying it in our gift shop yet, but we should work on that at the Historical Society. Thank you both so much for your time today, and we're grateful for how enlightening and the work you've done. I'll echo Professor Gordon's praise for your work, Professor Post. It's extraordinary and detailed and a real gift to the country to have this in one place now. Thank you both. Our next virtual lecture will take place on January 23rd at noon. Professor Amanda Tyler will be joining us for a discussion on the often overlooked history of Mitsuye Endo and her case Ex parte Endo. Registration is open on the Society's website at www.supremecourthistory.org. And finally, a survey will go out later this afternoon to everyone who registered in advance. We encourage you to respond to it. We added these virtual programs during the pandemic, and they've been so useful and well attended that we plan to continue them. Your feedback on them is very important to us in making them, helping make them as informative and engaging as possible. We thank you all for joining us today, and a particular thanks again to Professors Post and Gordon.
Thank you.
Pleasure.
Okay.